Hi class, this is Dr. Heather Austin Robillard, and this lecture video is going to be about the ethical and legal issues that are often common in substance abuse evaluations, as well as what you will be required to attend to as a licensed chemical dependency counselor. Again, moving forward, we will attend to the tasks and knowledge and skills from the ICRC exam, or what is expected from you as an LCDC that you will be tested on. And for this lecture, we will be attending to the professional ethics and confidentiality that's needed when working with individual clients. A fair warning in going into this lecture video is that we cannot cover all of the ethical issues and rules in just one lecture video, so make sure you're doing additional research, as with the exam you will be required to know all of the rules that are expected of an LCDC when you're applying for that license. Many clinicians go through an entire course just on ethics, so it's important to remember that we will be briefly going over the ethics required for a licensed chemical dependency counselor. This is a crash course, and we will only be focused on those that are pertinent for assessment and evaluation, which is what you will be doing with the substance abuse evaluation. Even for my own clinical choices, when in doubt, make sure you get consultation from a supervisor, from a peer, or somebody within the agency. So some definitions we want to go over, which were also found in your reading, include ethics. Ethics generally is a body of principles of what is right, proper, or what is good conduct in working with individual humans. A code of professional ethics is recognized and accepted by a specific member or profession or organization. It defines the standard of care expected of members of that profession to adhere to. The standard of care is the level at which an average, reasonable, and prudent professional would provide diagnostic or therapeutic services under similar conditions. Laws are rules that individuals must obey for the good of society as a whole. Laws are not necessarily ethics, and ethics are not necessarily laws. So just remember that if you are in a member of profession, you may have to follow laws as well as ethics. This can be frustrating because a code of ethics varies among certain professional organizations, states, and jurisdictions. But typically, those in the mental health helping profession share similar core moral and ethical principles. For example, an LCDC in Texas has specific ethics among the Texas Association of Addiction Professionals. The American Psychological Association also has a section on codes for the rights and responsibilities of test takers. So let's look at the core moral principles for mental health professionals. One of the core principles is justice. As a mental health professional, we want to be fair, equitable, and overall not be discriminatory. Beneficence is advocating for your clients and the public's well-being, as well as promoting mental health wellness. We want to do good and be proactive. Non-malfeasance is to do no harm. This is intentionally or through negligence to your client or the public. Autonomy. This is freedom of choice and action. Consider those with the inability to make competent choices. We want to make sure our clients have autonomy, which is why we can't do therapy while somebody's intoxicated. Fidelity and veracity. It is important for mental health professionals to be truthful and honor your commitments. It's also important for mental health professionals to be competent. We need to abide by the scope of our practice as well as our license. We should gain knowledge as well as supervised experience in order to make sure that we are competent in our careers. We also need to be competent in the impact of diversity issues on your testing and interpretation. This will also come into play with your competency and level of understanding of psych tests. For example, level A is tests that can be adequately administered, scored, and interpreted with the aid of a manual, whereas level B requires some technical knowledge of the test construction, use, and of supporting psychological and educational fields. For example, you might need a bachelor's degree or specific training for that testing. Level C is specialized. You either need a master's or a PhD or a specialized training and experience. The next couple slides, we will be talking about those rights for test takers. The first right for test takers and mental health clients is privacy and confidentiality. Test takers and mental health clients have the right for privileged communication. The legal definition of private is protected relationship between the parties and the courts, who have limited power to enforce disclosure in court, but not absolute. For example, an attorney and client has specific rights to privilege information. You'll want to know your state, jurisdiction, and licensing rules when it comes to privileged communication. Confidentiality. This is a legal and ethical duty to not disclose any information about your client. This is broader than privilege communication. Privilege belongs to the client. Only they can waive it. So you cannot reveal any information about your client. There are exemptions, which we will talk about later in this lecture. You do want to have safekeeping of their test answers and their interview notes, as we don't want to be negligent and let their information accidentally become not confidential. There are laws and jurisprudence that protects this confidentiality. For example, we will talk about consent for release of confidential information to specific alcohol and drug treatment. We will talk about HIPAA, as well as FERPA for minors and parents or students. In general, parents of a minor have the right, not the minor, to assent or consent to therapy. They have the right to know or the right to divulge that information. Again, know the pertinent laws in your jurisdiction because this might be different. There are some exemptions to the rights and privacy of confidentiality. For some jurisdiction or states, harm to self can also be a reason why we might reveal this information or break confidentiality. Harm to others, like homicidality. Child abuse and neglect. Elderly abuse, neglect, or those individuals with disability. In some states, domestic abuse and sexual violence. Sexual exploitation of the therapist. Or if there is an emergency situation where info is essential, or if there is a valid court order, which is what we call a subpoena from a judge or a consultant lawyer. The duty to warn, or when somebody reveals that they are going to harm themselves or others, is brought from the Tarasoff versus Regents law from 1976. This is stated that if a client communicates explicit threat of harm on a specified identified victim or groups of victims, and there is credible risk for the ability or intent to carry out this threat, that we have a duty to break confidentiality to the police or the potential victim. It is important to note that in Texas, the Tarasoff laws are not required. So as a clinician, I am not required to warn individuals. However, that is something that goes into the ethics, where a law versus an ethic might present a gray area. There is also an exemption to disclosing to third-party payers. For example, if insurance pays for your client's substance abuse evaluation or treatment, then they do have rights to certain information. Court orders for substance abuse evaluations also is an exemption. This is why it's important for individuals to understand their informed consent to an assessment or a substance abuse evaluation. They need to know what information is going to be revealed to the person that is requesting for them to have a substance abuse evaluation. Individuals also have the right to not be stigmatized, so we want to make sure we're using the least stigmatizing label. Rather than saying that somebody is an addict, saying that they have an addiction or have a substance use disorder, it is the least stigmatizing label. Individuals also have the right to be informed of the test and the test findings. We need to communicate it in a language that they can understand. We also need to figure out how to communicate negative results. We should learn to be sensitive to the situation and discuss the purpose and procedures of the test. We also need to understand and discuss the possible limitations and margins of error of the test and procedures used. We should also be available for questions and potential counseling for those adversely affected by this information. Again, with informed consent, test takers have the right to know why they're being evaluated, how the test data will be used, and what, if any, information will be released and to whom it will be released to. Again, this is important if they are being referred for a substance abuse evaluation from parents, treatment centers, probation officers. They need to understand all of this in their informed consent. At the beginning of a discussion, you need to have a conversation about informed consent, as well as have them sign the informed consent that they have read and understood it. I always go over it verbally as well to make sure that there's no miscommunication. When it comes to specific assessments, oral or written assessments, you should specify the general purpose of this test, specific reasons it is being undertaken in this case, as well as the general types of instruments to be administered in the assessment. It's also important to ask yourself these questions. How would you know if there is consent for treatment or assessment? There needs to be evidence of choice whether this person wants to participate. They need to demonstrate factual understanding of their issues and be able to reason the facts of the evaluation. They also need to understand and appreciate the nature of this situation. So, for example, at least legally an adult, parents have the consent for minors. So consider cognitive impairment from intoxication, mental health illness, or medical issues. They cannot consent to an assessment if they're intoxicated or if they're under medical cognitive abilities. Other rights that test takers have are to be treated with courtesy, respect, impartiality, regardless of their age, disability, ethnicity, gender, national origin, religion, sexual orientation, or other characteristics, which will be followed up in the diversity video. They need to be tested on measures that meet professional standards and that are appropriate, given the manner in which test results will be used. So we don't want to just find a BuzzFeed quiz for them. We want those to be evidence-based measures. When using psychological tests or measurements, we want to focus on common good. The tests are useful and public has confidence in its use. We don't want to use tests haphazardly. Only use tests within a professional context, not just for fun. Make sure you are qualified to administer and interpret those tests. We need to have extensive knowledge of the use of those tests as well as supervised experience. Do not share test and test information to public that would potentially bias its effective use in the future. For example, we don't want to show people how they can cheat on a specific assessment or test. Do not photocopy copyrighted materials. Other ethical issues to consider is dual relationships. Will your relationship outside of the helping profession relationship bias the assessment and interpretation? For example, let's say your realtor comes to you for an assessment. What should you consider and what should you do? If you have a romantic or sexual relationship, you definitely shouldn't be assessing them. And you shouldn't engage in a romantic or sexual relationship with anybody that you're giving assessments to. When in doubt of dual relationships, it's best to refer them out to someone else. This is the end of this ethical lecture, but please make sure you're going over the readings, and if you have any questions about ethics, you can refer to the professional organizations in your jurisdiction and state.